is not merely a matter of understanding how legal provisions have evolved, but it's more than that. This session will provide practical insights into the vital changes under the new labor codes, compliance challenges, and the strategic choices that organizations may need to make while navigating these developments. Today's session is organized by the Collective Council, a platform dedicated to bridging the gap between legal education and legal practice through practical learning initiatives, mentorship opportunities, skill based programs, and career focused training. Our goal is simple: to help law students and young legal professionals develop practical skills, gain industry exposure, and prepare themselves for successful legal careers. It is now my privilege to introduce our esteemed speaker for today's session. We are delighted to welcome Mr. Deepak Bhardwaj, sir, who is Associate Director at Grant Thornton Bharat LLP. Sir is a distinguished professional known for his expertise in industrial relations, labor code implementation, due diligence, and compliance advisory. Through his professional journey, he has guided numerous students and young professionals in understanding real world industry practice and skill building. Sir, on behalf of the Collective Council, I extend a very warm welcome to you.
Thank you, Shravani, for a brief but wonderful introduction. And as we all understand, the subject is quite comprehensive in the sense that uh, there is a lot of ambiguity attached to the subject because of the very nature of the subject. And we understand since labor law is something which falls into the concurrent list of the constitution, and therefore multiplicity makes it more difficult for a reader to understand it. Therefore, today's platform and opportunity both to interact with budding law professionals or students is an equal opportunity for me to learn and to deliberate upon the subject. Though this subject has been widely discussed for last few months across multiple platforms, but I'll try my best to have my views around the subject. Though it could be that many of you are aware of those points, but I'll try my best to just touch upon and give you a thought to ponder upon so that post this session, the readers are in a position to at least know some basic because I myself, I consider myself as a student again. So therefore, not claiming to be an expert in that sense, but yes, whatever I'll be discussing today or sharing will not bind my firm in any way. These opinions will be entirely my own views. So if so ever it creates any contradiction, my firm will not be held liable for that. So, so over to you, Shravani, and just let me know when to start.
Uh, Thank you, sir. It is a privilege to have you here. Without further delay, I request you to take over.
Great. So, for the benefit of everyone, I think as we understand this subject, why we are discussing it today. This is the very first question I ask to many of the students or whenever we go for a meeting with the industry player. Uh, because this was never discussed in the way we are discussing it today. The simple reason for that was previously, before labor codes came into reality, the subject was not never taken very seriously, and therefore there was a dire need to revamp the complete structure. Because if you compare the previous set of legislations which got subsumed into labor codes, they were not that relevant in terms of the evolving landscape of Indian uh, labor landscape, I would say. For example, we never heard words like platform and gig workers previously before labor codes. Though we understood that there were certain platforms where people of those nature of jobs are deployed, but no security, no platform, no recognition, no acknowledgement was there in terms of legislation or protection, I would say. So therefore, with labor codes, it all started, and people have started thinking. And obviously, yes, the penal provisions, the whole horizon has changed. So I'll give you a brief how it all started. It all started with very old 20 years ago with the National Commission on Labor. Therefore, at that time, in early 2000, it was thought of putting 40 plus state central legislation into five buckets. However, with the passage of time, those studies started but could not take the real shape. And therefore, with passage of time, again, when we had new government way back in 2014, the process again started, and instead of 40, 29 central legislation got subsumed into four bucket according to the nature of the laws. So now, with regard to that, we today we have four buckets. One, I'll simply take you the journey path of the code. Just give me a second. I hope my screen is visible.
Yes, sir,
Yes,
it's
sir.
visible.
Your screen is visible.
Right, right, right. Thank you. So, with five such labor codes bucket, one where we discuss things around wages, concepts related to wages are clubbed into one. Another one where we had social security and other platforms were put into another bucket, which is code on social security. Third, where we had matters related to industrial relations and harmony were put into third bucket, which was industrial relation code. And similarly, other occupational safety, health, and working conditions were put into fourth bucket, which was occupational safety, health, and working condition code. Now, these codes were notified way back in 2019, 2020. However, were never notified for their implementation, and therefore these implementations were pending since then. November 21, 2025, we got the notification for its enforcement, and therefore where it all started, and people started realizing its importance because it was just out of the moon, out of the blue moon, it came into the implementation, and therefore 21st November 2025 became a very relevant date. Post that, the government started coming up with different FAQs and clarifications around that and central rules. And so first FAQ came out in 30th December 2025. Post that, they came out with another notification with regard to FAQs and other things, dated 16th March. And then we had similar uh, notification of central rules on 8th of May 2026. Post that, central government notified few other things uh, around May end, which was related to the notification of ceiling limit under Provident Fund Act and ESIC and other social security aspects. And then post that, we could see that there are things like EPF schemes were launched, ESIC, EPS, EDLI schemes were notified on 20th, 29th June 2026. So we are seeing that a small journey, but it will take some time to evolve out of its current shape. And therefore, this subject will be evolved in next few years, not within a week or a month or a year. It will take few years to evolve out of its current shape. Now, what is the current status? As I made you understand that this subject is concurrent in nature. Therefore, both the central government and the central state governments have a role to play. And therefore, its implementation cannot be completed unless we see a parity, a harmony between centrally notified codes and state rules. And as we understand, till that time we do not see the state rules coming up, its implementation cannot be fully effective. And therefore, if we see, Bihar and Gujarat is the only state where they have notified all uh, their rules. However, states like Andhra and Rajasthan, they have notified partially few of the codes rules, but not many. Therefore, with such number of states pending with their notification, I think implementation will be delayed. But what we understand, the most of the states are actually working towards that, and we will very soon will see that in next quarter or so we'll see many state notifications will be coming up in terms of state rules supporting the implementation of the codes. And this is what I was discussing about the four buckets where I've seen, or where you could see 29 central legislation got subsumed, and like code on wages, you could see four important central legislation got subsumed, which is with regards to payment of wages, equal remuneration, payment of bonus act, and minimum wages act. Similarly, industrial relation code, which is primarily towards managing the industrial harmony, subsumed Trade Unions Act, Industrial Employment Standing Order Act, Industrial Dispute Act, and so on. So three acts got subsumed in IR code. Similarly, code on social security more or less Again, uh, 9 central laws got subsumed there, and similarly 13 acts were subsumed under Occupational Safety, Health and Working Condition Code, which actually uh, reduced the compliance burden and other burden drastically. And how that has happened, that is very important for understanding when we say the rationalization of the labor codes. For example, in previous regime, when we had multiple legislation, 29 central legislation, it had 1436 rules. Now, because of the labor codes has reduced to 351. Now you could see the reduction in terms of number of rules we had dependency upon. Similarly, returns from 31 returns to single return. Similarly, multiple forms which were like 181. Now they have reduced it to 73. 84 registers previously now have been reduced to 8. Similarly, 8 multiple registrations, I would say, to a single registration. License again, from multiple licenses to single licenses. So these are certain big grounds for rationalization in terms of implementation of the labor codes, and therefore we should not uh, take it negatively, because as we understand there is a extra burden in terms of penalties and other things, but there is a huge reduction in terms of compliance on the industry as well. The
Uh,
important point,
Excuse me. I see, Mr. Sir. Could I ask a question right now?
It is advisable that you can just write your question in the chat box, and towards the end of the session,
I'll
we'll
I'll,
put up the question.
I'll try my best to take up questions, but allow me to cover a little bit, and then surely I'll take up questions
Okay,
as well.
sir. Sorry to disturb you.
No, no,
My
not at all. Please,
apology.
please. Right, right. Now, moving ahead with that, I think what was missing in previous regime was there was no compounding. Uh, uh, Compounding factor was never there, and labor laws were never allowed to have compounding effect. Therefore, now the, the non-compliances can be compounded with certain penalties and other things. So that is a very welcome step in terms of implementation of the labor code. Similarly, a concept like improvement notice has been brought into reality, where uh, straight away the authorities will not penalize you, rather they will give you a chance to make your non-compliances good with a straight away direction and guidance, and therefore it will not be like a straight away show cause notice issued by the authorities. So these are certain welcome steps in terms of implementation of the labor codes. Now moving ahead, because we are very short of time, I'll skip few of the slides, but what are the changes coming up in terms of implementation of the labor codes? Now, see, first, why there was a need to have labor code. One, multiplicity of concepts. Like, for example, the very big problem in terms of having multiple legislation is that every legislation was speaking in a different language, and therefore, for every legislation, you had to refer different definitions, and therefore to reduce that multiplicity and ambiguity in terms of referring different definition under different acts for different calculation, like gratuity act had different definition, pf act had different definition, then bonus had different definition and other things, because of which this subject never universalized, in the sense that you could not follow single definition. Now the very prime objective of this labor code introduction was to universalize that, and therefore universalization of definition of wages became very important. And therefore, the biggest change which came out of the implementation of the labor code is universalization or uniformization of the definition, and which is same across all the four codes. So that is one, a biggest change. Therefore, when we see the impact of the labor codes implementation, we could divide it into two parts. One, where we see the financial impact because of the change in definition, and other are where we could see legal implications because of the terminology changes in definition, new introduction of the concept and other things, which I will try my best to take up within this presentation itself. So primarily, what definition of so coming up, starting up with the first impact, which is financial impact, where it says that uh, whatever you have as remuneration gets covered under your remuneration, whether you pay it by salary allowances or otherwise, or if you can express in terms of money or capable of being so express money, and by default it includes three factors: basic pay, DA, and retaining allowances, which are certain allowances are industry specific, So anything which you have committed to your employees are covered under your remuneration, and therefore, along with this, basic pay, DA, and retaining allowances will be covered in your meaning of definition when we say wages definition under labor code. However, they have given certain 11 exclusions where it says that these 11 exclusions will be different from this definition, and therefore if you club all these exclusions given cannot exceed 50% of the total remuneration. Therefore, what people have started interpreting that if you have rupees 100 as remuneration, then considering all the exclusions you can have in your cost structuring or your structure of the employee salary, maximum exclusion components you can have is up to 50%. Therefore, by default, your wages become 50%. It is not otherwise where government has given any uh, capping on the wages. Wages can go up to 70%, 80%, depending upon that how much your exclusions are. So I'll give you a small illustration around that in order to make you understand. So you just have to remember those 11 components in terms of the exclusion and other things. For example, scenario one where it says basic is your 8,000, HRA 4, special allowance 6, conveyance is 2,000, overtime 3,000, commission is 2,000. Your total salary becomes 25,000. So your total remuneration here is 25,000. Law says that cumulatively all your exclusion components cannot go beyond 50% of your total remuneration. Here, my total remuneration is 25,000. Therefore, what maximum I can go up to as total of my exclusion is 12,500. However, out of these six items, I would see HRA, conveyance, overtime, and commission are my excluded components, and therefore when I add those amounts, I find that it is only 11,000, which is less than 50% of my total remuneration. Therefore, this concept is fine, and my wages then now become 25,000 minus 11,000. Now here you can see my wages has gone beyond 50%. Therefore, as people are interpreting that wages can maximum go up to 50% is not correct. It can go beyond that, but yes, exclusion cannot go beyond 50% because capping is only for the excluded components. Similarly, if we see scenario two, similar case, certain tweaks in the figures, but if you see total remuneration here is 25,000, but because since we have changed little bit amount, so the total excluded component reaches to 13,000, which is above than 50%. More than 50%, my 50% becomes 12,500. However, I have 13,000 as my total of excluded components. So now law says that anything which is over and above 50% of total of the excluded components will be deemed wages and will be added back to the wages. And therefore, if you see my 5,500 rupees will be added back to my wages part. And therefore, here my wages will become 12,500 because 25,000 minus 13 becomes 12,000. However, 13,000 is more than the 50% of the excluded components capping given in the law. Therefore, additional 500 as deemed wages will be added back to the wages. And in this case, scenario two, my wages will become 12,500. So this is a very simple scenario, though this subject can become so complex depending on what sort of uh, structure you have, what sort of components you have, what sort of benefits you give, whether those are in kind or other things. So there are multiple angles attached to it, but I'm not going into that depth. I'm just making you understand how law has changed the definition of wages. And since this definition remains same across all the four codes, therefore becomes very important for you to understand the basic nuances. Not much depth about that is relevant at this point of time. So I think that is one of the point where I felt is important for you to understand that there is a financial impact attached to the implementation of the labor code. Another important point, what we've been hearing across different platforms, that there is a need to classify your population, and you must be hearing this across all the platforms as a student or as a working professional, that now there is a need to classify your workforce. Why? So therefore, I thought it becomes very important to at least share a little bit about why there is a need or whether there is a need or not. So when we say worker versus employee, yes, there is not even a single section which mandates you to classify your population. Then why we are doing it? This is the second question people asking, that if that is not relevant, why we are doing it. We are doing it because there are certain entitlements in the codes which are specifically for a worker set of employees, and there are other set of entitlements which are specifically for the set of employees. Now, when we see different entitlements using different nomenclatures, we tend to believe that, yes, there is a need to know how many of my employees, how many of, out of my total population, how many of them are falling into employee category and how many of them are into worker category. If I am planning to segregate those entitlement on the basis of the designation of title, which is one set of employees and other is worker. So that is how it becomes important, but no mandate as such, legal mandate is there in the law. So what all it covers under employee? So just to give you a brief about that, employee includes everybody, irrespective of what sort of skills they are hired for. However, on the contrary, worker again includes everybody, but both the definition having one common exclusion, which is for the apprentices. If you hire people under Apprentices Act as an intern, only and only exclusion available is for them only. Therefore, you have to be very careful if you hire interns but not covered under Internship Act available in India, which is Apprentices Act. And just to update, this Apprentices Act has not been subsumed and becomes independent even today. Therefore, you have to see the specific exclusion is only for the apprentices. Rest we have to substantiate before the authority if we believe that these are genuine interns. So for worker category, it includes everybody. However, in comparison to the employee definition, because employee definition is a wider one, when we compare worker definition with employee, it includes everybody, but two or three exceptions are given. Where one point where it says that if you are at a managerial or administrative position, you will not be covered as, or you will not be considered as a worker. One. Second, if you are in a supervisory capacity and drawing wages exceeding 18,000, again you are excluded from worker category. And therefore, if you see on the left side where I have covered employee definition, managerial and administrative uh, skills are or profiles are not highlighted in blue, because blue items are common and appearing at both the ends, and therefore one with a skilled category could either fall into worker and employee. Therefore, as I mentioned, skill is not a decisive factor, designation is not a decisive factor, your salary again alone is not a decisive factor. What actually matters is that you are employee unless you all are workers, unless you are falling into managerial administrative capacity or in a supervisory capacity with salary of 18,000. So excluding these two categories, rest all will be covered as worker. And that is the reason. And we have 80 plus judgments, both at Supreme Court level and High Court level, where courts have given multiple criteria to classify your population and basis a test to classify who all will fall into worker and employee. A long discussion we can have around this subject. But again, just to make you understand why this is important when we see labor codes implementation. So if somebody asks whether there is a need for classification of our people, yes, if in case you are planning to go ahead and give those relevant benefits to relevant set of employees, then it is important. But if you are not going to bifurcate definition entitlements on the basis of the designations you have or categorization of total manpower you have, then obviously there is no need to classify. But since we are not aware how that compliance and other structures would look like in future, therefore it is better to have those workings with you. Uh, it cannot be 100% correct. It cannot be 100% incorrect. But yes, to an extent possible, it is important for you to have those workings with you from a future perspective. Uh, I can skip that part because I've already touched that. And right, so this was very important, and I thought classification in terms of employee workers becomes very important. Now moving ahead with
Sir,
another.
good evening, sir.
Yes,
Sorry to
Anuj.
ask. So sorry to ask a question, sir. May I know the definition of unskilled workers and the examples and types of unskilled workers, which industries they are working? Like
So
in your previous slide, sir, the second point.
I got it. I got it. Anuj, it is very important. See, defining skill, so no such definitions are given except for the central rules where they have given definitions in terms of highly skilled, skilled, semi-skilled, and unskilled. So if we see, uh, if I take example for highly skilled employees are those where you see an independence in terms of decision making. Second, it is backed up by a considerable amount of experience. Third, you have an independence in terms of control over your decision making, and you have certain set of education supporting your roles and responsibility. That is how somebody gets into a highly skilled category, but this is very subjective. For example, a working in a software industry can be considered as a software engineer if they have 4 years of experience. However, in comparison to a space industry where you require a large amount of experience if you need to be classified as a highly skilled employee. So this is very subjective and changes from industry to industry. However, if we compare highly skilled with a semi-skilled or skilled person, I would say, so more or less what is missing if you compare it with highly skilled is one, the independence of decision making is not there. Second, considerable amount of experience is not there. Yes, they have on the job training, but yes, they need certain amount of vocational or other set of qualification, but not that relevant as it requires for a highly skilled. And if and and they skilled category of people are generally those where they are guiding either semi-skilled or unskilled, and sometimes they are being guided by somebody who is sitting at a highly skilled category. And this important point attached to this question is that now uh, this is important for all the organizations to classify their skills in the appointment letters, and therefore we see different set of appointment letter contents which needs to be there by each state. And since I felt this question is important, I took that up, that now you need to classify the skills of your employees in their specific appointment letters, whether they are old employees or new employees. So that is very important for you to understand. Now moving ahead, this was all in terms of the financial impact, and therefore with the change in definition, other there are many retireals like gratuity and other benefits, leave encashment, where you can see an impact either at a higher end or at lower end, because what we believe gratuity is something where we see huge financial impact coming for the organization, and therefore many larger organizations are now booking those provisions in their books because they see a rise in that liability. So with that, I think it is important for us to understand a very important aspect of the implementation of the labor code, because as I mentioned, this subject is concurrent in nature, and therefore both the central government and state governments will have a role to play. Therefore, duality is something which is being questioned many a times by not only by industry experts but by students as well, and they want you to understand that how this will play. Now we need to be mindful of few things before I take you to the nitty gritties of the subject. One, what the central government has done is that they have subsumed 29 central legislation. They have not touched any of the state legislation. So generally for state we have shop and establishment acts, and for managing, and that is generally for non-manufacturing. However, for manufacturing entities we have Factories Act and supported by state rules. Now that Factory Act has now been subsumed into OSH code, therefore that is changed, but state level legislation where we see Shop and Establishment Act for each state is still prevailing. And therefore we need to understand this duality concept, and we need to understand how that will play out, because there are certain components which are existing in both labor codes as well as in your shop and establishment direction. I'll give you one example. We have privilege leave or annual leave as an entitlement given by the states. Similar entitlement has been given to us under labor code, which is like 1 day leave for every 20 days. So in a nutshell, 18 days of leave is granted by labor codes for a for an employee. Now, more or less similar provisions are there in most of the Shop and Establishment Act, where either they follow the similar guidelines or they have defined the number, for example, 15 or 18. Now, these entitlements given in both the set of legislation, which one to go ahead with. And that is where organizations and legal experts are finding it difficult. So, to my understanding, we need to see what references we have in our constitution. Whenever there is a confusion or overlapping in terms of central law versus state law, obviously central law prevails. However, when we see a duality because the state governments have not repealed their state laws, so we cannot challenge the enforceability of those acts as well. Therefore, ministry has clarified through their FAQ dated 16 March that if you have certain provisions where you see a duality, we would request or we would urge the user or the industry to go with the one which is more favorable. That is how you can create a harmony. Because so far, uh, uh, Bihar is the only state where they have repealed their Shop and Establishment Act, knowing the fact that most of the things are now getting covered through labor codes, and therefore there is no need to have a separate legislation as Shop and Establishment Act. However, no other state has followed that path. Therefore, we need to see till the time we see a duality, we have to live in that domain. And therefore, a thumb rule to follow is that if you have compliances to follow, go with the one where you see more stringent provisions. For example, if state provisions are more stricter, go with the one where what state says, because by default you'll be adhering to the other one. On the contrary, if you have something related to employee welfare and benefits, then go with the one which is more welfare towards the workers. So I'll give you another example. For example, leave accumulation is there. Leave accumulation is when you could not use your entitlements given during the year, and now it is left unused with the at the end of the calendar year. Now, state law says something and labor code says something. Labor code says that obviously yes, you can take it to next year, you can accumulate those numbers up to 30. However, there are states where they say you can accumulate those leave and you can take those leave to next year and you can accumulate up to 45. Now, which one to follow? Because state says 45, labor code says 30. Now, if you see it from a welfare perspective of the employee, 45 is more welfare oriented because that one gives more number of leaves for the employee to be utilized in the future year. Second, more number of leaves there in terms of encashment at a future rate. And therefore, if you see it from an employee perspective, and if employee agrees to that, is more favorable. And therefore, ministry again has clarified in their FAQs that yes, those sort of positions can be taken. So, if another question you may have in addition to the labor, employee versus worker classification, that how to survive with the duality. This interplay is very important to manage, and therefore I've given you a thumb rule both in terms of compliances as well as a welfare related provision of the employee. There are other points attached to it. I'll take up in upcoming slides because I have covered that. So I'll skip this slide, which is wage settlement and overtime, then leave encashment. I'll cover everything in my upcoming slides if in case I have time left. But I would like to touch upon few facts or few changes, big changes in terms of codes, and therefore the changes, operational changes, in addition to the financial one which we have discussed. One, with respect to code on wages, I think it is important to understand that now the coverage has been widened. Previously, we had different legislation, had different set of industries. I'll give you a very good example. If we see Minimum Wages Act, the Minimum Wages Act previous was applicable to scheduled employment. When we say scheduled employment, we meant there was a defined set of employment criteria given in the act itself. Only on those specified scheduled employments the act was applicable. So that restricted the application of the law to limited set of employees or industry. Now there is no such bifurcation or application of the, yes, there could be different applicability of the chapters within labor code, that is noticeable, but in a totality, if you see, the codes are not bifurcated on the basis of industry. Therefore, we see a widened coverage in terms of applicability of the code. Therefore, Second point, concept of scheduled employment. Now in labor codes, what they have done is they have done away with that scheduled employment, and now they say minimum wages, for example, which was earlier as a separate legislation was there. Now it is one of a chapter in code on wages where it says now it is applicable to all. So that is how you could see a universal minimum wage framework is there. And now we will, with the passage of time, we will see a national floor wage across India, which will be like a base wages for every state to follow. States cannot have anything less than that. If in case they are, they have to revise it to match at least at par with the national floor wage. But if in case they are already higher, then they cannot come back. So that is the minimum protection the national floor wage will guarantee us. It is yet to be out and therefore not notified by any of the, sorry, has not been notified by the central government because this national floor wage will be released by the central government. Similarly, earlier the timeline for wages was dependent on how many number of employees you have. For example, if you have 1,000 or more employees in your organization, you can make those payments up to 10th of the month. And similarly, if you have anything less than 1,000, 7th was considered to be the due date for you. Now they have removed those dates and they have kept only one, which is 7th. And now they are saying that you have to make all those payments by 7th of the succeeding month. Now, what is the change then? Because many of the organizations already making it on the last working day of the month. The change is that now this provision is equally applicable to the contractor. And when we say contractor, means where they are working as an intermediary and providing employees to the organization as a contract worker. So this provision parallelly applicable to them as well. So this is a big change because now you cannot deny their benefits. So that is a sort of coverage code on wages have tried giving to the uh, you know the other sections of the society where they were not having coverage in previous legislation, though very explicitly. Similarly, under Occupational Safety, Health and Working Condition Code, important point is that one, they have restricted deployment of contract workers in core areas. And when we say core area, law says that whatever you have in your object and for which you are into existence will be considered as your core area, and any related activity which is there for the functioning of your main object will be considered as core area. So now it is again subject to interpretation and very subjective that how many of your operations will fall into core and non-core. Why I'm saying so? Because now there is a prohibition of deployment of contract workers in your core area. So therefore, permanent employees deployment is required in your core area. Therefore, under OSH code, you need to now understand how out of your total processes, how many of them are falling into core and how many of them are into non-core. Because now non-core is completely allowed to have contract workforce. So this sort of classification is now required, which is a new concept. Earlier, it was not there in Contract Labor Regulation Act. Similarly, there are certain provisions in terms of female working beyond a timeline, and now you need a consent, even for extending their working hours or working overtime. You need consent from both the employees, female or male. But for female employees, there are specific welfare and safety provisions are there. For example, they cannot work between 7 to 6 without consent, and if they are working, you need to make sure that certain guidelines are adhered and which are 8 to 10 in numbers. Like you need to provide them with the pickup and drop facility. You need to provide them with good number of female employees staying back at office, and other things are also there. So that sort of protection is there in terms of female employees working beyond a timeline. Now, leave encashment, again, very important. Previously, because of sometimes we see that most of the shop and establishment acts were not clear around leave encashment. Therefore, now they have made it very clear that any worker not using his or her leave during the year will be given encashment of those unavailed leaves at the end of the calendar year. And they have inserted other subsections by which they close the gap or loop for lapsing those unavailable. Earlier, what used to happen that if you have used, suppose I'm given 20 leaves and I've used only 10 and I'm left with 10 at the end of the calendar year, generally organization were lapsing the leaves. But now that cannot be the reality. You have to give them an encashment. However, yes, there are certain other provisions which allow them to carry it over to the next year for future use. And then once they reach that maximum limit, again they were entitled to get those encashment. But in a nutshell, net situation, if I would explain, there is no room for leave lapse. Now leaves will be encashed whether at the end of the calendar year or post reaching the maximum accumulation limit. That is another big change in terms of OSH code. Another important point in terms of all the labor code is inspector cum facilitator concept. Now, what they've done is the intent of the government here is to move towards a compliance framework where people are willingly moving towards compliances and not because penalties are now much more than what it used to be earlier. I'll give you a small example. There was a factor which was previously charged with a penalty of 5,000. Now it has gone up to 2 lakh rupees. So that sort of jump they have created in labor code. Therefore, since the intent of the government here is to make you, work towards compliance, and therefore concept like inspector cum facilitator has been used, and therefore they have changed that nomenclature from inspector alone to inspector cum facilitator because now their role will be to facilitate you in terms of moving that compliance, and therefore instead of giving you show cause notice at first instance, they will give you a chance if in case any non-compliance observed to make it good with a clear direction and time. Modalities around that is yet to be notified, but yes, this is what we could gauge out of the simple reading of the law. For code and social security, I think two important points or three important points what we could see is one where we see an exception under gratuity rules because payment of gratuity act has now been subsumed under code on social security, therefore which wherein earlier the gratuity is applicable to any employee who completes 5 continuous year of services with an organization. However, for an employee who is termed as a fixed term employee, the moment he completes 1 year with you, and when we say fixed term employees, meaning thereby that they are hired with an end date to their contract. So if you have an end date to your contract, you are termed as a fixed term employee, and therefore, unlike other employees, regular employees, where they have a start date but not an end date to their contract, uh, fixed term employees are coming up with a gratuity exception, though we have an exception for working journalists also, where we see a 3 years exception, unlike 5 years for other regular employees. So these two exceptions are there. But yes, because fixed term employees are widely used across industry, therefore becomes very important that if you hire fixed term employees, you need to pay them gratuity the moment they complete 1 year of service with you. Similar period, factor with regard to code and social security is a 5 year period of limitation. When we say limitation becomes very important because uh, these legislation were used to be very complex and that sometimes inspection became a hurdle for the organization to move ahead because uh, 10 years 15 years records were open and people were finding it difficult to sustain with. Therefore, government has come up with a 5 year limitation period, which means authorities can now maximum go back up to 5 years, and therefore the look back period for the authorities is fixed at 5 years, which is a pro industry step because now maximum period they are answerable to is for 5 years. And very important point under code and social security that now they have provided an acknowledgement to the fact that we have another set of employees like platforms and gig workers, what we could see in Zomato, Swiggy, Uber, Ola, etc. So they have given those set of employees a recognition. Therefore, uh, again they will be getting a protection under those legislations. But we are yet to see the modalities and schemes and frameworks around that. Therefore, it will be a passage of time, or only with the passage of time, it will be clear that what sort of coverages they will get. But surely, yes, their existence has been acknowledged, and we understand that a protection, like we understand a certain amount of turnover is something which needs to be uh, submitted to authorities so that their welfare schemes can run. So these sort of classifications and protections are there for platform and gig workers under code and social security. Last but not the least, industrial relation code, where we see uh, few things have been relaxed. For example, applicability of standing order, which was earlier applicable to any industrial establishment having 100 or more, has now been increased to 300, and therefore, which is again a pro industry step, because now to have a standing order, whether you are a manufacturing or non-manufacturing, is important the moment you cross 300. Similarly, concept of fixed term they have allowed to be utilized in your industry if that is for a very limited period with certain exigencies, but it should not be taken as a replacement to your regular regular employees or employment roles which are perennial and core in nature. So certain other relaxations are also there in terms of retrenchment and layoffs, where previously uh, it was applicable to organizations with 100 or more, but now they again have raised it to 300. So those sort of uh, relaxations are there in IR code, and therefore industry with lesser number of employees are not that burdened with compliances. Another important point is in terms of grievance redressal mechanism, because earlier, if you had any parallel mechanism in order to manage or take care, to take care of your grievances within the organization, was taken as a compliance. However, now with labor codes, they have made it mandatory for any organization with 20 or more workers. Again, here they have used the title workers, and that is how you could see different entitlements are using different nomenclature in terms of the workforce classification. And therefore, if you have 20 or more workers, then you have to have a grievance redressal committee in place. So before I jump to the implementation roadmap, how we can plan that journey, I'll touch upon few missing points which we missed out in previous slides. This wage settlement. Again, a very hot topic, because now what you must be hearing across all social platforms, that now it is important for the organization to make the payments within 2 days. Yes, that is correct. And just to highlight, this is not a new concept. It was previously also in existence. The only change with labor codes is previously 2 days settlement was only restricted to uh, cases where you had uh, you know termination initiated by the organization. Not it was not included for any of the voluntary separation. Now they have included cases for resignation also. So that is the change, and therefore law says that the moment they leave the organization, within 2 days you have to make sure that the wages part of that employee is dispersed within 2 days, and that includes leave encashment. If you have any leave, standing to your credit, the encashment of those leaves again needs to be released to that employee within 2 days. Now, again, this becomes a very big challenge for the organization to deal with, because now if the employee having certain assets with them, they need to plan proactively so that everything gets completed and payments are dispersed to employee within 2 days. But we need to be careful of the fact that it does not cover gratuity. Gratuity says that there is a timeline of 30 days to disperse your gratuity to the employee. Therefore, it will not cover those aspects where those entitlements are with certain additional statutory timelines. Like I've just mentioned, gratuity is one of that factor. But other parts which are forming, getting a coverage into your wages definition will surely be released within 2 days. And ministry has clarified through their compliance handbook also, which they released during these months. Another important point which you must be hearing across all the platforms, that now it is important for organization to pay overtime. Yes, it has now been mandatory, though it was there in most of the shop and establishment act previously also, but now they've clarified that now you have to make sure that overtime is being paid to everybody if they are ready to work or extend their regular working hours. So regular working hours are like 8 hours every day without rest intervals. Similarly, 48 hours in a week, and week comprises of 6 working days plus one off day, which is like a weekly off. So if you're working for 6 days, it would be 6 multiplied by 8 is your limit. But if in case you're working for 5 days, your working limit for the week will become 40. And therefore, anything which goes beyond 40 will be your extended working hours. And therefore, you need to see on a daily basis or a weekly basis, whenever you see any extension to those limits needs to be paid accordingly, which is 2x of your daily wages. For example, if you have 100 rupees as your hourly wage, so any extension of an hour will be paid 200 rupees because overtime wages are 2x of your hourly wages. Leave encashment, I think I've already covered that in detail. That now leave encashment is something which is very much mandatory, and therefore, because of the change in definition, there was previously organizations were making it on basic wages, which was not uh, legally valid. But now, since they have to move the definition from basic to wages, which is as per the labor code. Therefore, they see a rise in terms of financial numbers when they see that now they have to make those leave encashments to their employee at the end of the calendar year. Prohibition of contract labor, I've already discussed that now there is a complete restriction of contract labor in your core area. Now, I think I've touched upon most of the important points. It is a very detailed subject. We can have discussion around this for hours and hours, but just to make you aware a little bit, clear around what that subject covers. But there are most of the things which an organization needs to do before they plan for that journey, because now with the change in definition, one, they need to see what their contracts arrangement with the employee, third party, the contract manpower and other things are there, and accordingly anything which stands in contradiction to the provisions of the labor codes which were notified for enforcement on 21st November stands void if they are in contradiction to that. One, second, they parallelly need to review their policies. They need to make amendments to that, because again those documents, again, if not in conformity or not in consonance with the law, you need to make those amendments so that they are in as per the directions of the law. Similarly, you need to recheck your structures, components, whether the basic minimum guidelines given for the wages definition, which says that your component, excluded component, should not exceed 50%, whether that aligns. If that does not, then you need to match to the basic minimum criteria set by the law. So those sort of process and implementation processes you need to take care of. And before you know diving much into this, I'll request employees or attendees today to ask questions if in case, because we are already short of time. I
Thank
believe
you.
this subject is a bit confusing for everyone, but again, just to start with, I think I have kept it very simple. But let me know if I have questions, relevant questions around that.
Thank you so much, sir, for that insightful and engaging session. I request all the participants to kindly ask your questions right now.
Sir, my query is that does India has done labor law revolution right now by introducing these four codes or not?
See, when we say revolution, it does not take shape within a day or so, to be honest, Sujal, because see, there are again with labor codes, after the enforcement of the labor codes, we could see there are areas where we need improvement. But yes, it is a step towards that, and therefore this government has done a tremendous job in terms of providing a simple four set of legislation rather than multiplicity. Yes, it is a revolution because I didn't get time to and this subject is, as I mentioned, is a very deeper subject. But we could see there are definitions which has taken all the judicial precedents into consideration, and therefore they have refined the law to the extent possible. And therefore, and when we see it from the lens of those uh, insertions or changes, amendments, we see that the government is working towards this. For example, this prohibition, uh, this entitlement of power was always there with the state governments under Contract Labor Regulation Act previously, but it was subject to state governments uh, authority. So I think Andhra was the only state where they came up with the prohibition on of the contract labor. No other state used it. However, we always had unfair labor practice schedule in Industrial Dispute Act, where any job which is of permanent in nature cannot be done by a temporary workforce. Provisions were there, but implementation was not that effective, even though we had a prohibition in the state like Andhra. And I could, very well say that this is my experience that it was not implemented at the ground level. Therefore, when you see it from a central law perspective, people are now taking it more seriously. One, because of the central laws and the central authority involvement. Second, the uh, nature of uh, shift from earlier penalty exposure now, as I mentioned, the 5,000 to 2 lakh rupees is a huge jump. So yes, it is a revolution. Again, no revolution is completed unless it evolves. It takes certain years to evolve, and it will take few years, like what we could see in GST and other laws. So whenever you have new law, it will take its own course to come out of its real shape.
Okay, sir. Sir, my another query is that does labor laws apply in arbitration cases or not?
Yes, it will. I mean, it see. Recently, we had a question around that when courts have challenged that, and but again, one should not comment upon that because it will take its own course, and therefore it would be too early to comment upon that. Like recently, what we have understood is uh, just a day ago, we had a judgment from the Supreme Court where they have clarified industry definition. So I'll refrain from commenting that much on the definition or your question, but yes, it will have a very critical role in terms of arbitration as
Okay, thank you for clearing my queries, sir.
well. Right. So, Shravani, I think we are
Uh,
already over time. Uh, so if we have
yes,
anyone, we can take one more questions.
Yeah.
yeah, one or two some basic questions. This factory act, could you please focus, throw some light on the factory and some research and development organization has been removed from the factory. Are you aware or sir, like, or could you guide us? And the extension to the question, like, hiring the contractual worker, is there any provision if the contractor fails, or make a default of the payment? So what the responsibility of principal employer lies? So will he
Right.
continue the terms of the employment, the payment, or they can terminate within 3 months or 3 months is the maximum criteria? So
See,
that's the
with
thing.
respect to factories, that earlier the mechanism was that Factory Act was considered to be a central legislation. We had uh, different state rules to support that. Now, since that Factory Act has been subsumed under oversight code, therefore, many of the states, what they are doing is they are coming up with different set of rules supporting both factories and other areas of the code. So yes, now there is a shift in that regard. Now coming back to another question, uh, that if what if the contractor fails? See, this provision is not new. Earlier also, the similar provisions were there under Contract Labor Regulation Act, where it says that whenever you have a failure from the contractor, the principal employer, where those contractual employees were deployed, was responsible to make those payments. Now, but there were certain judicial precedents available with respect to payment of bonus. Now, with labor codes, what they've clarified again is that principal employer will remain liable. I'll give you one more additional example with that. Earlier, it was on the contractor to provide certain welfare benefits for the contractual workforce working with the principal employer. But knowing the fact that that premises belongs to someone who is considered to be a principal employer, therefore this authority or this obligation cannot be shared with, I mean, this contractor was not responsible for making those changes because he was not having any authority on that premise. And now labor courts have clarified that and made it very clear that if that premises belongs to principal employee, it will be principal employee's liability to make sure that yes, those are paid and given to employees, a contractual workforce. Similarly, any dues, as I mentioned, 7 days timeline, which is equally parallel to uh, the contract workforce. So there is no disparity in terms of benefits or entitlements, both either to regular employees or to contract workforce. But yes, if any benefit, any start benefit, if the contractor fails, will fall upon principal employer to make sure that is adequately and timely paid to them.
Thank you.
Sir, this is Jalandhar from Suryadatta Law College, Pune. I have one query related to new labor code. Sir, that central government has already implemented new labor code, but many of the states had, as of now, they have not made a rule, or though that they already made a rule, but they have not yet implemented. So whether organizations are liable to implement the new labor code, or they should wait for the state rules to come.
So very important question. See, if we go back and check our constitution, where it clearly one, First question, whether enforcement is there? Yes, the law is very much enforced from 21st November 2025. It is, there is no doubt about that. So that is very clear. Now, because we need, why you are asking this question? Because which is a relevant question, because every law is supported by a set of rules, and since we do not have state level rules, because for OSH code, IR code, and code on wages, your appropriate government will be your state government where you have your presence. Therefore, it is important for those organizations to have state rules before them. So, therefore, they have this question that how to implement or how to make the implementation effective if we do not have state rules in enforcement. For this, we have to go back and check our constitution where it says that if any law is enforced but not supported by rules, so till that time you do not see any contradiction coming up in the older rules. The older rules will be assumed to be very much effective and will support the functioning of the new rules to the best. It does not create any contradiction. But there are provisions where, if in case you see a contradiction, you have to wait for the state rules. So I'll give you one example to that, like retrenchment previously. If you retrench somebody or if you terminate some worker from the organization, you need to pay them earlier. In a previous regime, you have to pay them retrenchment compensation and 1 month notice. This was all in previous law. Now in this law, labor code, they have added one more factor to it, where they are saying that in addition to these two factors, or in addition to ensuring these two factors, you also have to ensure that you are paying them the worker reskilling fund. Now, this worker reskilling fund is something which is new in nature, and therefore there was no reference of worker reskilling fund in previous law. Therefore, no reporting, no compliance can be done unless you have a new rule in place. Therefore, till the time and to the extent possible, you have references from the older laws, one can implement that, but where you do not see any fresh reference, for example, returns. No state rules have notified their annual returns so far, except a few states. Most of the states are only having draft rules. Therefore, obviously, you can't have new forms as your annual return. Therefore, to rely or to comply with the codes, because codes are implemented, you have to go back and file the formats, assuming that you are filing it under the new law. Therefore, what we've been doing for many of our clients, that we are doing, though we are doing filing it in the older forms, but with a caveat that it is presumed to be filed under labor code. So that sort of clarity we have from the constitution, that you can have a dependency, and that's what General Clauses Act also says, that if you have a dependency on the older laws, unless it creates a contradiction, you can have a dependency on that. So that is very clear. So effectiveness is very much there.
Yeah. Thank you, sir.
So, so I think, Shravani, if in case we have further questions, they can reach out to my mail. We can surely have a discussion. And you can share my uh,
Surely, sir.
contact details. We can have.
Surely, sir. Sir, before we leave, we request all the participants to fill the feedback form, and let's take a virtual group photograph. So please kindly turn on your cameras. Sir, could you turn on your camera? Yes. Thank you, sir. Perfect. Uh, As we come to the end of today's session, I would like to extend my heartfelt gratitude to Mr. Deepak Bhardwaj sir for taking time to share his valuable knowledge, practical insights, and perspective on the evolving labor law landscape with all of us. I'm sure all of our participants have gained practical knowledge than just the classrooms and textbook interactions. Thank you, sir, for making this session so insightful and engaging. Thank you everyone for joining us. We look forward
So,
to seeing
so
you.
Shravani, before you close, just a
Yes,
simple,
sir.
simple comment. See, this subject is very deep. One cannot digest it or explain it within an hour. So, therefore, just to give you a thought, and because I'm still a student, so I'm not claiming to be an expert of this subject, but it is important for you to understand, because this scope as a practitioner will have huge impact on your career if you take it very seriously. So, I would urge all of the legal professionals to, practice on this subject, because we hardly find good practitioners on this area, though we must be having thousands of them, but yes, not in that number what we require. So if in case you feel anything which is not understood by you, I'm just a call away. Call me anytime. I can explain those concepts. But uh, my apologies in case I was not able to explain that because of the limited time. I have.
Surely, sir, we'll reach out to you. And thank you, everyone, for joining us today. We look forward to seeing you again in our upcoming sessions and learning initiatives. Until then, have a great evening, keep learning, and stay connected with the Connective Council. Thank you and goodbye.
Pleasure connecting.
Thank you.
So
Bye.
much.
Take care.